Thank you for joining us this beautiful spring day. My name is Patrick Doherty. I am the Deputy Director of the American Strategy Program here at the New America Foundation. I want to thank Philippe Sands and Colonel Lawrence Wilkerson for joining me today, and you today, and express the deep regrets of Steve Clemens, who, due to a personal conflict that cropped up at the last minute, cannot join us today. As we know through his blog, The Washington Notes, Steve has a clear pecking order when it comes to the people he respects, and Philippe Sands and Lawrence Wilkerson are at the top of his list. Unfortunately, the emergency arose, and he sends his apologies. In contrast to the gorgeous weather outside, today we are gathering to talk about one of the darkest elements in one of the most dismal chapters of American history. We were talking about how the most senior officials of the American government authorized torture, cruel and unusual punishment, and inhuman and degrading treatment. In 1863, as Philippe noted in his Vanity Fair article, President Abraham Lincoln, a proud member of the Republican Party, established the standard of conduct for the treatment of enemy combatants by the U.S. military. It was a political necessity. By 1863, it became clear that the war between the states would not be won on the battlefield by trained and uniformed armies alone, but only after the South had lost the will and ability to further prosecute hostilities. President Lincoln, like all good presidents, also thought beyond the termination of violence, toward the period of Reconstruction and a healing of the Union. On the one hand, he could not legitimate the rebels of the Confederacy as the soldiers of a sovereign state. On the other hand, he knew that inhumane treatment or mass summary executions for treason would poison the North-South relationship for generations. So in fighting a war to preserve a Union based on law, and in fighting to end the inhuman practice of slavery, President Lincoln knew he had to uphold a higher standard. On April 24, 1863, Lincoln signed General Orders 100, which stated, "Military necessity does not admit of cruelty, that is, the infliction of suffering for the sake of suffering or for revenge, nor of maiming or wounding except in fight, nor of torture to extort confessions." The story we are about to hear today is about the undoing of Lincoln's legacy and the legacy of every president since. Telling that story is Philippe Sands, professor of law and director of the Center of International Courts and Tribunals at University College London. He has litigated before the International Court of Justice, and Philippe broke the story about the Bush-Blair memo agreeing to lure Saddam into a war. And his latest article in Vanity Fair, The Green Light, comes from his new book, Torture Team. Here it is. Torture Team, Rumsfeld's Memo and the Betrayal of American Values. It's on sale, as you noticed, out front. Philippe just returned from testifying to the House Judiciary Committee, and he has promised to regale us with the latest developments from the Hill. I think you'll find them interesting. Responding to Philippe's presentation, we are honored, as always, to have Colonel Lawrence Wilkerson, with whom I have the great privilege to work when I wear my other hat as director of the U.S.-Cuba Policy Initiative here at the New America Foundation. Colonel Wilkerson is the Pamela Harriman Visiting Professor of Government at the College of William & Mary and a lecturer at George Washington University here in D.C. The Colonel was most recently Chief of Staff to Secretary of State Colin Powell during much of the period of Philippe's story, having worked for General Powell in the office of the Chairman of the Joint Chiefs of Staff previously. If you ask Colonel Wilkerson to describe himself, however, more often than not, you will hear him say he is trained as a strategist in the most elite national security academies our nation has to offer. He served 31 proud years in the Army and saw combat in the Vietnam War. And with that, I warmly welcome Philippe Sands. He'll speak for about 20 minutes, and then Colonel Wilkerson will make some comments, and we'll turn it over to questions and answers. So please help me welcome Philippe Sands.
Thank you very much for the invitation to be here. It's my second appearance, and I'm absolutely delighted to be here. I'm going to really paraphrase what this story is about and then talk a little bit about what happened this morning and where things may go. It's the story of a single memo. The last book that I wrote was broad brush across the range of international legal issues that Britain and the United States faced. In this book, I've taken a single piece of paper, the famous memorandum signed by Donald Rumsfeld on the 2nd of December 2002, in which he authorizes 15 out of 18 techniques of interrogation for use on a single detainee at Guantanamo, detainee 063, Mohammed al-Qahtani thought to be, or alleged to be, the 20th hijacker. Al-Qahtani was discovered to have been in Guantanamo in June 2002, and his discovery led to a series of decisions which ultimately resulted in the adoption of a memo signed by Mr. Rumsfeld, which apparently for the first time broke with the prohibition on cruel treatment. The administration has spun a narrative as to the circumstances in which that memo came to be signed. I was interested in that narrative because it was plain on its face that the techniques that were used on Mohammed al-Qahtani over a period of 54 days, and the interrogation log was leaked, and so we're pretty familiar with what happened to him, violated Common Article 3 of the Geneva Conventions and violated various provisions of the Convention prohibiting torture. I needed to satisfy myself what level of abuse had happened. That's not purely a legal issue, so I went and consulted with a couple of independent experts, clinical psychiatrists, to assist me on the test in international law for torture, severe mental pain or suffering. And on the basis of the advice that I received, and in particular Dr. Abigail Seltzer's clear and unambiguous view that if you put 12 clinical psychiatrists in a room and asked the question, was this man tortured, not one of them would say he wasn't. So that is the premise in relation to the treatment. Now, what struck me as problematic, but I approached my inquiries with an open mind, was that the administration spun a narrative which described this as a bottom-up thing. They presented, in the face of the Abu Ghraib catastrophe, a story which essentially said, we don't do torture, the abuses at Abu Ghraib have nothing to do with administration policy, and to prove that, we will show you how careful and rigorous we are when we go about dealing with these things. And they put out a number of documents, including the famous Rumsfeld memo, recommended to him by Jim Haynes, his general counsel, attached to which were an originating memo of request from Major General Mike Dunleavy, Reserve Army officer, normally to be found in the Court of Common Pleas in Erie, Pennsylvania. His legal advisor, the Staff Judge Advocate Lieutenant Colonel Diane Beaver, essentially an 8-page single-space memo that signs off on these techniques. A forwarding memo from General Tom Hill, the commander of the United States Southern Command based at Miami, and then, of course, the action memo written by Jim Haynes on the 27th of November 2002, signed by Mr. Rumsfeld a few days later. And the narrative sent a very clear signal. We were simply responding to the legitimate needs, requirements, desires, perspectives of those who are on the front line, down at Guantanamo, trying to decide what to do with someone who may possess information that we want to extract. And who are we to interfere with such a legitimate request? And in telling that story, which is most clearly stated and set out by an appearance of Jim Haynes, Alberto Gonzalez, and Dan Delorto, who has now succeeded Jim Haynes as acting general counsel of the DoD following Mr. Haynes' departure to Chevron, was a press conference they gave on the 22nd of June 2004, which they appeared before the world's media and basically said, Abu Ghraib's got nothing to do with us. When we do things properly, and we, the administration, simply react to legitimate requests from the ground. Oh, and there's been a lot of rumor about a memo signed by Jay Bybee on the 1st of August 2002, redefining torture and various other things. That was just stargazing, had no impact on administration policy or on decisions, and we have essentially set that to one side. Now, I looked at that material, not with an academic's eye, I have to say, but with a litigator's eye. Doing court work, appearing in cross-examinations, there was something about the way in which the story was presented, and it was reprised by Jim Haynes in July 2006 when he appeared before the Senate Judiciary Committee. And he really rather blatantly finger-pointed Diane Beaver, the lawyer down at Guantanamo, and Mike Dunleavy, who he referred to as an aggressive Major General. It didn't feel right. And so what I decided to do was to try to meet every single one of the people that I have identified just now, as well as all the others who were down at Guantanamo and involved in the decision-making process. And in a period of about 15 months, I managed to identify them all, track them down, speak to them, all of them on the record, with the exception of Jim Haynes, who allowed me 2 off-the-record meetings, although the fact of our meeting significantly was on the record. And that, of course, is very significant because it allows me to set out my conclusions, making it clear everything he said to me over 3.5 hours I have fully taken into account in setting out my conclusions. And the story that emerged from that exercise was rather different from the one that they have told. And the book really sets out that story. I think, in a curious way, it conforms to most people's understanding of what is likely to have happened. But the difficulty was there wasn't really the hard evidence, because until the book came out, no one had heard from General Myers on this issue, or Mike Dunleavy on this issue, or Diane Beaver on this issue. If you Google the last 2, you won't even find photographs of them. They have never spoken about these issues. I'm deeply grateful to them for having opened themselves up to me and having met with me and spoken with me. And I think one of the questions I've been asked most often is, why on earth did they do it? And we can all speculate as to why that is. But the fact is that they did it, and the story that emerged was very different. The story that emerged was that, firstly, a conscious decision was taken to set aside Geneva for the explicit purpose of allowing aggressive interrogation. I wheedled that out of Doug Feith, who graciously allowed me a single meeting. At one point I put to him, after he had elaborated for me his theory of why no one at Guantanamo had any rights that they could rely on under the Geneva Conventions, I simply put it to him, isn't the consequence of that, Mr. Feith, that all the constraints of Geneva on interrogation are gone? And his response was, precisely, that was the point. Not a view previously articulated by the administration, who have always presented this as the sort of mechanical application of the legal rules to the consequence. So it became pretty clear that that was the first part of the plan. Get rid of these wretched international constraints, clear the page, and allow us then to set out the rules that we then want. I talk only about the military interrogations. I'm not focusing at all on the parallel system of CIA interrogations. My own suspicion is that the desire to go down this route for the military was driven in large part by Mr. Rumsfeld's sense of competition with what was going on at the CIA, and a desire to be able to match what they were doing. But others, Jane Mayer and so on and so forth, I think will take that narrative forward. What then became apparent was that the pressure for, the design of, and the selection of interrogation techniques was directly connected to the upper echelons of the administrations. And in a sense, the center of gravity of this story is a trip that was made to Guantanamo in late September 2002 by Messieurs Addington, Haynes, Gonzalez, and Rizzo of the CIA. And the conversations that I had with Diane Beaver and with Mike Dunleavy on that issue were absolutely crucial. Put yourselves in their position. Imagine you are the combatant commander. You are a staff judge advocate of almost no experience on these issues. And the president's lawyer, the vice president's lawyer, and the Secretary of Defense's lawyer descend on Guantanamo and talk to you about Detainee 063, what are you getting out of them? Talk to you about the need to take things as far as necessary, even watch an interrogation, and then leave. That sends a particular signal. It also sends a particular signal at a time by which I've now established to my satisfaction Jim Haynes knew the contents of the memorandum written by John Yoo and signed off by Jay Bybee on the 1st of August 2002. And this is, in a sense, the $64 million issue. If you watch the testimony of Mr. Haynes before the Senate Judiciary Committee on the 11th of July, I think it is, 2006, he ducks and weaves between the various questions put by the senators. Did you have the memo? Did you inform the contents of the memo? Did you contribute to the architecture of the memo? The one question, the key question that they didn't ask him, and it's in nowhere criticism, was, did you know the contents of that memo when you signed your memorandum? Of course, the senators didn't know at that point that he'd been down to Guantanamo in September 2002 and had been involved at that stage. Nor did they know that when the documents came up from Guantanamo a month or so later from the office of first Mike Dunleavy and then General Hill and made their way to Chairman Richard Myers, Chairman of the Joint Chiefs of Staff, that the legal analysis that Diane Beaver expected the Joint Chiefs to carry out was never carried out because, as Jane Dalton, General Myers' lawyer, told Alberto Mora, Jim Haynes short-circuited the process, interfered, took the documents away, and proceeded to take them straight to the Secretary of Defense, so that the normal processes of decision-making were circumvented by direct action. And one finds from all of this material, in a sense, a rather simple story indicating that everything came directly from the top, that the top was deeply and directly involved from the earliest stages, and that the reliance that was placed in the official story on the documents produced by Mike Dunleavy and the legal opinion produced by Diane Beaver were a smokescreen. And in essence, I think what has really added gasoline, shall we say, to my inquiries on this issue is not just a sense of really very deep concern that a country like the United States, which has done more than any other to put in place global rules outlawing this type of treatment, should have resorted to these types of measures, but that there was a cover-up in explaining what had happened. And that I find, at least I would say, as objectionable as the commission of the crime, because it really evidences, shall we say, a weakness of spirit and a failure to take responsibility. And if you want that articulated in the clearest possible way, it's in the manner in which Major General Dunleavy's document and Diane Beaver's were released to the press on the 22nd of June 2004, very dramatically, as some of you will remember. Those two individuals were given no real warning that that was about to happen. Amongst lawyers, we have a long-standing, very important principle, which is that you don't release legal advice except in extremis and under the most closely guarded conditions. And even then, you find ways, if appropriate, to black out the names of the people who have given the legal advice. Diane Beaver's name was not blacked out. A lot of the documents that have been released have had important names removed to protect the well-being and the identity of people, military people who have long served the United States honorably and well. That didn't happen. And the reason that it didn't happen was that these two individuals, amongst others, became useful scapegoats, the term that I use in the book, to explain what had happened. So it's a story of crime. It's a story of crime, I think, committed by lawyers. I describe in the book the circumstances in which, under international law and domestic criminal laws, a lawyer who participates in this type of activity crosses a line not just of giving bad legal advice, but into criminality. And it is a story of cover-up. I've been very fascinated by what has happened since the Vanity Fair piece has come out, and I think it's quite clear that without the Vanity Fair piece, the attention that has been given to this issue would not have come. It's been striking, I was discussing it with a couple of people beforehand, that the mainstream news media really isn't interested in this issue. It's toxic, they don't want to have anything to do with it, and the reasons for that, I think, are long and complex. But the blogs are all over it. if you follow what is going on in the quality blogs and the less quality blogs, you will find literally tens of thousands of pieces being written on my material and on related materials. You'll find a couple of pieces in the Washington Post and elsewhere focusing on it, but I think it's testament actually to the bravery of the folks at Vanity Fair that they were willing to put alongside Madonna a cover which talked about the commission of war crimes. And that has had an immediate effect. The control of the House, as you know, has changed, you know far better than I do, and the chair of the Judiciary Committee, who's someone I've got to know over the past 3 years, has long been interested in these issues. And following the publication of the Vanity Fair piece, he convened a hearing, which in fact was held today, on these issues. I testified along with 3 others, 2 others selected by the majority and 1 by the minority. And I have to say it was a completely fascinating hearing. It was preceded by a decision relating to the appearance of Mr. Addington. The committee appears to be going through the exercise of identifying every single one of the lawyers and other actors, because I think they will go higher up, that I have identified, and are inviting them to appear before the House committee. I think that a great number of them are now going to come voluntarily. I can simply share with you that this morning the intention was to vote on a resolution adopting subpoenas for John Yoo and for David Addington. By the time that resolution came to the floor this morning, Mr. Yoo had changed his mind and indicated that he would now come voluntarily, and he will come shortly before the committee. And Mr. Addington has indicated in an exchange of correspondence that some of you will have seen that if subpoenaed, he would come. And so a subpoena was in fact voted on this morning, and interestingly there was no objection to that subpoena from, no votes against from the minority. So the process is now very much underway. It was, I thought, a really fascinating experience. I've never testified before in this country. I've done it in the UK. It's a rather different experience. But what was very striking for me was firstly the number of actually rather impressive congressmen who were there in terms of being extraordinarily well prepared on the issue. I think it would be really inappropriate to go through a whole list of them, but I can strongly recommend to you the questioning by Congressman Davis of Alabama, who is obviously an extraordinarily impressive individual, of the minority witness, David Rivkin, in which, frankly, he just skewered him completely. It was an extraordinary piece of advocacy, and it indicated where the committee is going to go. It's quite clear that the committee is going to take this much further. Some people will say it's too little, too late, it's not fast enough, but it is happening. A subpoena has been issued. The focus of the inquiry is on the role of the most senior administration lawyers in the design and implementation of interrogation techniques. And it is quite clear that the issue that the committee will be focusing on is not just the consequence of the commission of international crimes by various individuals, but also the cover-up that followed in relation to the activities of these most senior individuals who one assumes were acting on the instructions of their political masters. And the political masters happened to be, at the time, the 3 most important men in the United States. So this is serious stuff. It continues to astonish me that there is so little interest in the whole thing in the mainstream media, but I suspect that with the passage of time, and in particular if a new administration comes in of a democratic hue, and in particular an administration of a President Obama, this issue will go very, very far. And it will raise and uncover all sorts of issues that are going to make, I think, for very interesting and, in the case of some, very uncomfortable reading. The hearing was interesting for another reason. I was acutely aware of my position as an outsider. Although I'm married to an American, although my 3 kids have British and American nationality. Of course, I'm a Brit, and there's always a sense of, it's generous of you to have me here, but I realise you're going to listen to me politely and then ask yourself the question, what on earth is this guy doing coming to talk to us? But it was actually, what surprised me the most was the positive nature of the reception that I got, not just from the Democrat side. And what resonated, there were moments that resonated, and there are others here in the room who saw what happened. What moments that resonated for me in particular was a moment when I explained why in the United Kingdom, across the political spectrum, left, right, Labour, Tory, Prime Minister, Leader of the Opposition, going down the route of coercive interrogation is a total no-no. And the reason is very simple. We had the experience with the IRA, and we know that it doesn't work, and we know that it extends the conflict, and we know that it creates a backlash, and there is no advantage whatsoever to going down that route. And I think what was striking was that particularly on the Republican side, I sort of got a sense of a failure to appreciate that others have been there and we might have learned a lesson by speaking to them and thinking through what the consequences would be. And the reception that I got from the Republican side, I think, pleased me because it indicated that there was, on this committee at least, a recognition not to descend into sort of partisanship and bickering, but actually focus on these substantive issues. There was also another very telling moment. I was asked what mistakes might have been made, and the first example that I gave, and I claim no originality for it at all because it is a universally held view in the United Kingdom, is you don't call this thing a war on terror. It is a very, very foolish thing to do. Why? Because you basically elevate criminals, mass criminals, into the status of warriors, and you provide conditions in which they are able to recruit more easily and they are able to fight their struggle more easily because they have been given a legitimacy. And the reaction from that, Chairman Conyers told me afterwards, was a remarkable one. One of the congressmen, and I'm not going to say whose name it was because I'm worried I'm going to get his name wrong, and I don't want to cause any political difficulty or embarrassment for anybody, immediately intervened and said, I'm totally with you on that. And Chairman Conyers told me it was the first time since September the 11th that he had heard any Republican express the view that the concept of the war on terror was a mistake. And that, I thought, also was an interesting moment. I picked up a degree of receptivity to these issues that surprised me. I expected far more hostility. I didn't get that sort of hostility, and it is plain that the committee is now underway. I'll conclude just with one observation, and I know Larry Wilkinson also has views on this, and I'd be very interested to hear what he does think. What ought to happen next? We were all asked that question. In answer to that question, I said I thought what was really important was that the committee used its powers to get to the facts. I think it's really not for me to be making recommendations on special prosecutors and this sort of thing. It seems to me that the rest of the world is looking at this stuff. And the rest of the world wants to know that the United States is getting its act together and that the United States is, at the very least, sorting out the truth about what happened. What happens after that is very, very different. What happens after that really depends on what the facts are and what they indicate. But I also explained to the committee that the context of this happening is that the crimes that have occurred are international crimes. They are violations of the Geneva Conventions. They are violations of the Convention of 1984 prohibiting torture. Both of those conventions impose obligations on parties to investigate, prosecute, or extradite to a place where an individual will be prosecuted. And they therefore are premised on a system of universal jurisdiction. And as I describe in the book in a concluding chapter, having met with a European prosecutor and a European judge, these investigations are, to all intents and purposes, underway. And the European judge and the European prosecutor said to me, and I describe it in the book, that in a sense the most foolish thing of all that has been done is to attempt to create an immunity in the Military Commissions Act of 2006, which of course has the effect of leading prosecutors and judges in other jurisdictions to conclude that there cannot or will not be a proper investigation in the United States. And that fact removes the obstacles to foreign intervention. And this is not pie in the sky. I mean, I spend my professional life as a barrister litigating these types of international cases. When these individuals, if they choose to set foot in some countries outside the United States, do so, they will face difficulty. I'm not, scaremongering, it's not pie in the sky stuff. Mr. Rumsfeld already has had to beat a hasty retreat once from France. Mr. Haynes has a job as General Counsel - Corporate, which apparently doesn't require him to do a great deal of international travel, and that's probably extremely sensible because the context of the United States failing to take even the most minimal actions internally is that the rest of the world is going to step in where the United States doesn't. I just want to conclude with one anecdote to indicate to you that the scrutiny of the outside world is not the scrutiny, as David Rivkin put it this morning, of a bunch of loony, lefty, nutter activists. I'm paraphrasing. It's not exactly how he put it. At the book launch for this book in the United Kingdom, which was held last Wednesday, the speaker of the book launch was our Chief Justice, Lord Bingham. Now, you just need to pause for a moment and ask yourself, could that happen in the United States? Could the Chief Justice of the United States Supreme Court speak at a launch event for a book called Torture Team, and in England it's called Cruelty, Deception and the Compromise of Law, but it's the same book, which looks at the crimes committed by lawyers and their political masters? And of course the answer to that is blindingly obvious to all of us. The feelings outside the United States on these issues, the feelings of disappointment, the feelings of anger, the feelings of irritation, the feelings of loss that the country that has done more than any other to put in place the system of international rules and promote the rule of law has abdicated its role, is palpable, it is strong, it is held across the entire political spectrum, and it is held at the highest levels of government and of the judiciary. And that, at the very least, ought to be sending out a very, very strong signal for everyone in the United States. Thank you very much.
Thank you, Philippe. And I think on that note, it's a good transition to Colonel Wilkerson, who I know is personally pained by what has happened, what he has witnessed. He and General Powell, Secretary Powell, and William Howard Taft IV strenuously objected to these the events that occurred that Philippe talks about. And without further ado, I just want to welcome him up to the podium.
I find it extremely painful to find again and again suspicions that I had that were very strong suspicions immediately after Secretary Powell asked me to look into this matter in the spring of 2004 as the publication of the Abu Ghraib, some of the Abu Ghraib photographs was imminent, to learn that my suspicions were not only right, but the things that actually happened were probably worse than I envisioned or suspicioned. It's no feeling of euphoria with which I listen to these sorts of things, nor that I read Philippe's galleys when he sent them to me. I hope the editor didn't change too much. I think his book is an indictment of 6 men, John Yoo and Jay Bybee at OLC in the Department of Justice, Jim Haynes, OSD General Counsel, David Addington, Counselor to the Vice President, Gonzalez at the White House at that time, Counselor to the President, and another lawyer, and the number 3 man in the Defense Department, and whose book I am laboring through right now, A Labyrinth of Lies, Douglas Feith. A labyrinth very well constructed, though, which he and his boss, Donald Rumsfeld, and others like Steve Cambone and Jim Haynes, as was just illustrated to a certain degree here, had an incredible knack of preparing the paperwork for, in case of any eventuality. I think Mr. Rumsfeld must have sat at his desk and contemplated the dozen or so things that could have gone wrong with any decision he made, and then written a snowflake or a memorandum on it so that he could then pull it out later when his decision, as they inevitably did, went awry, and justify the fact that he and Doug and others had taken a hard look at that possibility. And it was probably just the military as the executor, or whomever was the executor, that fouled everything up in the first place. If you read Rick Sanchez's new book, I think you'll see that in spades with regard to the man who was hurled into Iraq from his position in Germany with almost no passover to Tommy Franks, Abizaid, or anybody at the Central Command. He simply got it. It's yours now. We're cutting out. We're going to write our book and make our money. One of the things that Patrick said, I think, that's brought out in another book, Joseph Margulis's book about a year ago, Guantanamo and the Abuse of Presidential Power, which stunned me when I read it because he had gotten his hands on essentially all the documents I had, but had to surrender when I left the State Department. And one of the things you said about a dark and dismal period in our history is absolutely true, and Joseph says in the lead into his book, this is worse than Japanese in internment camps under Roosevelt. This is worse than the Alien and Sedition Acts. This is worse than the Espionage and Sedition Acts. This is worse than the Star Chamber that began right after World War I, the predecessor to NSA's looking at people's telegrams and reading them in the basement of the White House, resealing them and running back to the White House and giving them back, or running back to ITT or the Western Union or wherever they got them from. This is worse than any of that. This has besmirched America's reputation and her prestige, and therefore injured her power across the globe. Another thing that was said, I'm going to paraphrase you here, but you said the normal process of decision-making, this is what I teach, I've got to talk about this, I'm going to say was avoided, subverted, bamboozled, overpowered, pick your pejorative past tense verb. This is not something that hasn't happened in the past. It happened with Henry Kissinger when he became, as Bob Dallek has pointed out in his book, co-president. I would say he was president during the Watergate period, when he indeed took upon himself not only the mantle of National Security Advisor, but also Secretary of State. It happened when Robert Kennedy became the essential covert operation man for Jack Kennedy when he was President of the United States. All covert operations entered into and came out from Bobby's office. He was the Attorney General, my God. This is not something new to our system, but it is something new to the extent of the damage done and to the extent of the departure from the statutory decision-making process. I don't think it's happened in this way with this little talent to manage it once it had escaped the system ever before in our history. And the other unique aspect to it, of course, is something Douglas Feith goes to great pains in his book to avoid talking about, the most unprecedentedly powerful vice president in the history of our republic. And the last thing I would say is that when Colin Powell walked through my door in the spring of 2004 and said, LW, which is what he called me, I want you to put together a dossier, a chronology. I want to know how we got to where we are now. I want you to look at classified, unclassified, whatever you can get your hands on, sources. I've got Will Taft, Will, his lawyer, looking at it from a legal perspective. I want you to work together. I want you to be able to tell me what happened. The first thing I did was call the Defense Department. I'd already had a lot of experience with the Defense Department. And I found out that Admiral Church had been appointed as head of the group doing the same thing for Donald Rumsfeld. We talked, and we agreed that we would exchange information and so forth and so on. Never heard from him again. After I'd compiled what I could and sent it over to the defense, I never got a document from them except by subterfuge, by methods that I could use because I knew the Defense Department after serving in it for 31 years. That told me something. But then something else happened, and Philip referred to this. Can I call you Philip, or is it Philippe?
Either will be beautiful.
Powell began to go outside, normally in front of the Harry Truman building on the C Street entrance, and it didn't matter who it was. It could be the foreign minister from India, it could be Jack Straw, it could be whomever, And the first question inevitably he would get would not be about the relationship or the talks they just had, it would be about torture or about abuse. And he would answer almost the same way every time. Our system is going to show to the world how a democracy deals with this kind of problem. There is going to be accountability. And if you recall, as we went into the election period, there was Senate Armed Services Committee hearings, there were House Armed Services Committee hearings, there were hearings that essentially, as I recall, Donald Rumsfeld in the wake of one and in the imminence of another said essentially publicly that I will resign, I will leave if I have to. The president reassured him that he didn't have to. Bottom line, we thought there was going to be some real accountability, some significant accountability. It hasn't happened. It hasn't happened. Where there has been accountability, it has been the kind that we soldiers know all about. For example, when a sergeant from Bagram in Afghanistan or Abu Ghraib in Iraq or Guantanamo or wherever gets hauled before a court-martial and the charges are this, that, and the other thing, heinous in some cases, and they get a slap on the wrist or 6 months or reduction in grade or something like that. We know what's happening. We know that the people sitting on that court-martial, which is probably, in my view, a hell of a lot more, a better place to be than a civilian court. The people sitting on that court-martial, on that judgment panel, are saying, we know what happened. We damn well know what happened. And we're not going to throw the book at this guy. But that's the only kind of accountability that there has been. And I've talked with some of these gentlemen. It's not very reassuring accountability with regard to our democratic republic. And if Philippe's book and what he's uncovered and what Jane Mayer at the New Yorker and Tim Golden at the New York Times and a host of other people who gave me more of my dossier than the classified documents have discovered over time, if it doesn't bring some kind of accountability at the highest levels, then we should be searching our souls deeply to see if we really believe what we say we believe in. I'll tell you frankly, and most of you probably know this that travel a lot, the rest of the world does not judge us by what we say. They judge us by what we do. And what we have been doing is not very good.
I'm not even going to try to follow up to that. That's a powerful indictment. What we're going to do now is turn it over to questions and answers. I'm going to take a stab at some admittedly weak first questions, and hopefully this esteemed crowd can do me proud. What I want to ask Philippe gets to a different question, and it's you described yourself as self-described as a Brit. Why did it take a Brit to tell this story to the American people? Was there a failure there? And what happened that it took you at this point in time to tell this story? And then to Colonel Wilkerson, if I may, you talk about accountability. We've talked in the past about how do you get a system of decision-making that will not allow these things to happen. You spoke from this podium 3 years ago and said that in 1947, some very senior Americans said, we got very lucky in President Franklin Delano Roosevelt in that he was a smart tyrant, but God save us if we ever elect a dumb tyrant. What do you recommend? What's your prescription in terms of both accountability and new decision-making procedure? But Philippe, could you just tell us what you think?
I'm going to slightly reformulate your question, because I think that maybe the easiest is to stand up.
Please.
Because I've only looked at a tiny piece of the story. In a sense, I've done the easy thing. I've taken one tiny piece of the puzzle and used it to basically tease out all the bigger issues. And the technique is well known to any litigator. You basically home in on one part that is manageable. And I've had the great benefit, of course, of being able to rely on the work of many other people, Americans, very fine journalists, some of them in Washington, some of them in New York, some of them in other parts of the country, who have been beavering away on these issues, trying to dig up different bits. And you'll find in my footnotes literally hundreds of references to documents, tidbits of information that have been uncovered by the process. I think all of that work is truly magnificent work. I think that it's striking, nevertheless, that the administration has got away with a great deal, and I think the mainstream media has a lot to answer for in that regard. I'm not signaling any particular news organization or newspaper or journalist, but so in that context, I reformulate your question. How is it that a Brit got some of these people who'd never talked before to talk about these issues on the record? And that isn't, I think, a question that I've reflected on a lot, largely because I get asked it a lot. And I think it's a very complex question. I'm still working out what it is. I had some extraordinary encounters with extraordinary people, and I think one of the reasons I haven't been hammered by the neocons or by Republican congressmen on the committee this morning is that it's abundantly clear from the Vanity Fair piece and from the book that I have an enormous respect for the United States, for everything that has been achieved, for its contribution internationally to the rule of law, but that there were a few bad eggs, and the bad eggs weren't at the bottom. The bad eggs were at the top, and I'm essentially engaged in a process of getting a discussion going on accountability on this narrow issue. And I think that explains why people talk to me, because I didn't present a particularly hostile sort of investigative threat in the sense that I undertook to everyone I spoke with to present their material as fairly as I could. And again, it's a technique at the English bar and in English court is let people hang themselves by their own words. You don't need to say very much once you have laid out the material. And I think the most striking thing about the material from some of the individuals concerned, I probably shouldn't mention any name in particular, but I do feel Doug Feith is a name that is worth mentioning because it was extraordinary that he was able to articulate a deep sense of pride by his association with some of these things. Other things he was a little less comfortable sharing, and there was a rather remarkable moment when I asked him when he first became involved in these adoption of the interrogation techniques, and he pointed out that it was after the Haynes memo of the 27th of November had been signed by Mr. Rumsfeld on the 2nd of December. And I said, well, that's very interesting and a bit surprising, Mr. Feith. He said, oh, yes, why is that? He said, because look what the memo actually says. I have discussed this with Doug Feith. He stopped, looked at me, and just said, it's pronounced Feith, actually. And I'm afraid that it's, access by being, I suppose, a generously minded Brit. You'll be interested in the UK. I've been attacked for being too generous to these people, for being too generous to the people on the ground, and for not going after some of them as hardly as one might. And I think that explains the answer to your question. I'm not a journalist. I'm a barrister. I happen to be a Brit. There's a healthy friendship towards British nationals, and that encouraged people to talk. Whether I'll ever be able to do it again is another matter.
We hope you don't have to. Colonel?
Does this work?
Yes, it does.
A barrister knows he can't piss the judge off or the jury. I'll make a little pitch here, a commercial for Jim Locker's effort. Many of you probably don't know what Jim is doing. Jim was the principal architect for Sam Nunn and Barry Goldwater on the seminal amendment to the 1947 National Security Act, most often referred to as the Goldwater-Nichols Act, which essentially made the armed forces of the United States what they are today in terms of their joint staff, their education, their training, and so forth. It turned the joint staff from being a very desultory, average, run-of-the-mill staff, for example, into being the premier military staff in the world. one of the problems Mr. Rumsfeld had when he came in to take over the Pentagon. And I can understand why he felt he had to do some of the things he did, because the Joint Staff ran circles around the political appointees in particular, but many of the civilian bureaucrats too. My point on that is simply you don't degrade the military in order to bring them down to the civilian level. You educate and train the civilians to bring them up to the military level. That's the way to deal with that problem, and that's part of what Jim Locker's project is looking at right now. But it's much, much larger than Goldwater Nichols, because he's looking at the entire federal bureaucracy, to include the Congress of the United States. There are several congressmen, senators, and representatives who are involved, I'm glad to say. I talked to Senator Hagel's staff this morning, for example, because I didn't think he made Jim Locker's testimony before the SFRC the other day, and Hagel's staff assured me that he did. But Jim's going to be meeting with Senator Hagel and others. This is a very important effort. I agree with my boss, Powell, Eisenhower, and a number of other people who've said, quite rightly, I think, over time, that people are the real issue here. You got to elect someone other than an idiot. That's the real issue. But that's not necessarily in our control, is it, with the system we have in this country? Let's just face it, we've got 300 million people in this country, and we may be going Bush, Clinton, Bush, Clinton. That's an incredible indictment of our political system as far as I'm concerned, but it's what we have. So what Jim is laboring with is the malorganization of our government. Let's face it, it was done for what purpose? It was done because we were the most unprecedentedly powerful country in the world in 1945, probably far more powerful than we are today, and we suddenly had to confront this power and the fact that we really liked what we'd been before. Civil liberties, individualism, human freedoms, and so forth. We really liked it. So these very bright people got together and created the 1947 National Security Act in an attempt to compromise between those two poles, to protect us against a monolithic threat with a very poisonous ideology, the Soviet Union and communism, while at the same time trying to secure our civil liberties. They had a lot of problems and a lot of imperfections over the half century or so that intervened. But now we're in a new century, a new time, new threats, new problems. We need a new National Security Act, and that's what Jim is laboring on. One of the things in that act, and it's got lots of things in it, as you might imagine, but one of the things that intrigues me is to change the oversight mechanism in the Congress. This is going to be very difficult because chairmen do not like to give up their jobs. We need some broadly conceived committee in the Congress. Maybe it's a joint committee of both houses on national security, that instead of looking at stovepipes, the 150 account for state, the Commerce Justice account for state, the account for DOD and so forth, looks at everything that constitutes national security, oversees it from that perspective, and has some influence on appropriations from that perspective. Another proposal has been, and this one's truly radical, but it may take something like this, we have militarized our foreign policy to the point of view, or to the point where we have proconsuls in every region of the world today wearing 4 stars, just as surely as Rome had proconsuls. Those are the senior diplomats in every region of the world. Ask any combatant commander and he'll tell you that is true. Ask any undersecretary or assistant secretary of state and he'll tell you that is true, or she'll tell you that is true. So one of the proposals is to take the assistant secretaries who are regional at the State Department, elevate them to undersecretaries, and plop them down in Stuttgart, in Honolulu, and every place else there's a combatant commander, and plop them with their staff and make them in charge of the unified command, and the 4-star military officer and his staff their deputy. That situation would reverse in time of actually declared war in that region. That's a radical solution, but it's going to take something like that to turn this imbalance around or to correct this imbalance. When you have a Defense Department, and I spent 31 years there, I'm the last person to take money away from defense, but when you have a Defense Department that with supplementals is getting $750 billion and a State Department that is getting $35 billion, something's wrong, ladies and gentlemen. When you have a Foreign Service that couldn't even outfit a combat brigade, something's wrong.
If every American citizen or a majority of us are content with having a national security state bordering on a garrison state, that's fine. If that's what the American people want, that's fine. I don't think it is. I just don't think they know what's happening.
Okay, with that, we'll open it up. I think Walter Slocum, I just wanted to recognize you. Thanks for coming. If you had a question, I'd defer to you.
Well, I have a question on the substance. In the Vanity Fair article, you cite the argument that was made for non-application of Common Article 3. It's pretty clear that the people that you're talking about do not qualify as POWs under the Geneva Convention, so really the application of Common Article 3. Could you just comment on the substance of that? Because there's a in order for there to be a crime, there has to be a cover.
Sure.
In order for there to be a cover-up, people who make inadequate or stupid or mendacious defenses of their political actions are not fair criticism. It's not a crime. And I think it would be interesting to me and I think other people to get your perspective on underlying substantive issue, why the decision was wrong, which I think it was.
It's a really excellent question, and in a sense, if you want to see the clearest example of a misleading effort in addressing this issue, it's the 5 pages out of the 900 that Doug Feith addresses in his book War and Decision to the Geneva Decision. I'm going to simplify hugely, but in short, under the Geneva Conventions, certain individuals, combatants, are entitled to prisoner of war status. And that prisoner of war status gives them certain privileges and rights. You lose your privileges and rights under the Geneva Conventions to have prisoner of war status if you don't follow the rules, if you don't wear a uniform, if you attack civilians, and so on and so forth. I'm simplifying greatly. And on that basis, the administration decided, apparently largely on the theory articulated by Doug Feith, that prisoner of war status was not available to Al-Qaeda because they were not part of a state entity and therefore they had no rights since Al-Qaeda wasn't a party to the convention. And the Taliban individuals weren't entitled to prisoner of war status because they didn't meet the rules. They didn't wear insignia, they didn't wear headbands, they didn't wear uniforms, this sort of stuff. And so on that basis, they set aside the prisoner of war status. But Geneva has a floor below which no one can go, a sort of residual rule for everyone else, to all intents and purposes, and that is Common Article 3, which says that no one, under any circumstances, may be treated outrageously or tortured, irrespective of whether or not they have the status of POW, combatant, or protected civilian person. And the legal advice that came up in January 2002 and the argument of Doug Feith simply ignored the Common Article 3 issue. And in particular, to give you the clearest possible example, there are international authorities, decisions of international courts and tribunals, that have established that in circumstances such as these, the conflict was of a kind, a non-international armed conflict, in which Common Article 3 applied. So, for example, the International Court of Justice in 1986 ruled that Common Article 3 dealt with the Nicaragua situation. And the Yugoslav War Crimes Tribunal in the late 1990s ruled that Common Article 3 dealt with the situation concerning the breakup of the former Socialist Federal Republic of Yugoslavia. And these international decisions were simply ignored. They were bypassed entirely in the legal advices, and they didn't reappear until the judgment of 2006 in the Supreme Court in July in the case of Hamdan versus Rumsfeld, when the majority on the court, by 5 votes to 2, Chief Justice Roberts didn't didn't sit on the issue because he had sat in the Court of Appeals. And the only two justices who opposed the application of Common Article 3 were Justices Scalia and Clarence Thomas. Both, it turns out, to be aficionados of 24. There may or may not be a coincidence there. But the majority of 5 simply referred to American prior practice, relevant international authorities, to conclude that a conflict such as this was governed by Common Article 3. And Justice Kennedy's separate opinion, in many ways, is the most interesting one because it raises the spectre of war crimes. So you don't need to take it from me. You can read Justice Kennedy's separate opinion. And, of course, the consequence of the impact of the Hamdan versus Rumsfeld decision was absolutely dramatic, because once you accept that Common Article 3 does apply, and once you accept that none of the detainees at Guantanamo even got Common Article 3 rights, the only logical conclusion in law is that there were violations of Common Article 3. That gives rise to war crimes under the Geneva Conventions. And that is why the administration moved in the Military Commissions Act in 2006 to try to create an immunity for any person who was involved in the design, implementation, or application of these techniques of interrogation between September the 11th and December 31st, 2005. I'm very careful in my use of words here because I'm not an expert on the Military Commissions Act, and I gather there's a great doctrinal debate as to whether or not the intention to create an immunity actually does so effectively. So I'm not expert enough to get into that. But the bottom line of it is the administration itself perceived that there was a war crimes issue. And I describe in the book a colleague of mine who happened to be having lunch with Jim Haynes when the Hamdan versus Rumsfeld decision came down and was told to him, and describes him literally going white as a sheet, because at that moment he will have known not only that war crimes were committed, but that his own neck was on the line, because he, of course, had drafted the memorandum that Mr. Rumsfeld signed in December 2002, and which plainly violates Common Article 3. Now, how you move forward in addressing that violation is a complex issue, and I'm certainly not proposing that all of these people should necessarily be prosecuted through some criminal process. That may be one option, but there are other options that other societies have dealt with in dealing with these issues. They have had truth and reconciliation commissions. They have had other efforts to essentially bring closure where violations of the criminal law had happened. But what strikes me as totally intolerable is the hubris that informs the reaction. If the people I had met, including the people right at the top of the administration, Mr. Fife, Mr. Haynes, had said to me, look, bear with us. It was the anniversary of September the 11th. We had credible information there were more attacks coming. We had an individual who we truly believed held information that we could use. But with the benefit of hindsight, we now recognize we fell into error in good faith, and we accept that errors were made and ask for your indulgence in cutting us some slack, and we will make damn sure this never happens again. I would have a completely different attitude to it. But there is not a hint of regret. There is not a hint of recognition of anything problematic. And we see most recently in the decision by President Bush to veto legislation from Congress, which would have outlawed for use by the CIA the identical techniques that I write about that were used by the military, basically saying, we want to keep the door open to be able to use this in the future. And that has sent the most terrible signal to the rest of the world. And for that reason, frankly, I think these people deserve what they get. They have not shown the slightest remorse, the slightest hint of recognition that they may have got it wrong, and they are therefore exposing themselves to the critical scrutiny of others. But the simple point is, there was a violation of Common Article 3, and with that violation of Common Article 3 comes exposure to international criminal investigation.
Okay. Harlan Ullman.
I have more of a declaratory statement that I'd like you to respond to in a parliamentary question. It seems to me that the issue, despite your marvelous forensic examination, really is political. I mean, you had either a collision or a combination of an administration in which the role as commander-in-chief put you above the law, and you had Attorney General findings to prove that proposition, or at least to state it. And the notion that terrorists presented such a clear and present danger that any means were fair and free to try to extract information because national security was at stake. This is an ideological view that's still held. And in political terms, I would argue that many Americans tend to share certainly the second view, that if you had, take the extreme case of Ahmadinejad flying a jet aircraft with 3 nuclear weapons, would you shoot him down? The answer is of course. I mean, that's a ludicrous question, but it makes the point that we are in such a dangerous position that we have to take these steps. And when you take a look at it, when Congress was debating what to do about rules of torture, I would argue that Congress not only forswore its oversight, but in taking on the president, people like John McCain collapsed, and the president got exactly what he wanted in terms of keeping open these options. So it seems to me that politically, you have not only a chief executive who's on board with this, but a complicit Congress. And quite frankly, I don't see how you're going to be able to turn that around. I mean, I know you're optimistic about removing this particular stain, but when you have an administration ideologically that says it didn't break the law, irrespective of Common Article 3, it seems to me it's going to be very difficult outside filing some sort of indictment overseas, making it very difficult for the people that you name to travel. Inside the United States, I just don't believe that this is going to go anywhere.
I have to say, I fundamentally disagree.
I hope you're right.
And I may be wrong. And why do I disagree? I think I can say it in the simplest terms. I think these things take a long time to sort themselves out. I'm not for a moment saying all of this is magically going to get sorted out in the next 2 months. There's going to be hearings and so on. That's not at all what I'm saying. This is the beginning of a much longer process. And the experience of other cases that I've been involved in, take the case of Pinochet, a case that I was involved in 10 years ago now, 10 years ago this autumn. Senator Pinochet left office in 1990. I mean, the gravamen of his crimes dated back to 15 years earlier. I mean, the real horrors were committed in the mid-1970s. So you're talking about, by the time he was arrested in London, the passage of almost 3 decades. And yet, at the end of the day, something happened which has had a profound effect on society in Chile, and which took a long time to get there, but which eventually got there, and in which immunities were set aside. You find exactly the same thing going on now in Argentina in relation to the dirty war. I think it's part of the norm that a country's system of government takes some time to cut into action to deal with these issues. It happened perhaps in this country a little earlier. I mean, it's pretty remarkable that the US Supreme Court actually called on some of these issues, really rather bravely, at the time that it did. And America is a country which has self-correcting mechanisms, which cut in relatively early, and which indicates to me that I think with the passage of time, and it may be less time than I imagine, these problems will be addressed in a way that allows the country to move forward and allows others outside the country to say they've got their act together. But I appreciate entirely what you're saying. There is a part of me that's deeply concerned that President Bush's administration has moved the goalposts and made torture legitimate. It's extraordinary now in talking to people how many people share the view that you have just expressed, and I think it's going to be a big job to shift that. But I think the reason it'll be shifted is that the United States will come to recognize that it's not half as powerful as it believes it was, and the United States has a vested interest in an international rule of law. The United States has to deal with a resurgent Russia, a growing China, a developing India, and the United States is going to recognize is that actually it's done rather well with the system of rules that it put in place in the mid-1940s, and that it will serve its interests to return to that system of doing it. And of course, going back historically, many of you know this far better than I do in this room, there has always been a system of ebbs and flows in terms of connections with this country to matters international. And my hope has to be that the low point was reached, and we're now seeing the beginnings of the bounce back, and there will be a reconnection. But I may be horribly wrong. I may be horribly optimistic. I accept that entirely. But I've got to say, sitting in that committee room this morning, I mean, the country is entitled to allow itself some measure. I'm not going to say sort of backslapping, but there was a hearing that was held. Strong things were said. A committee has got the bit between the teeth. And I think one has to allow oneself some measure of optimism that these issues are going to be addressed, and that the one person on the committee who expressed a counter view, Mr. Rivkin, frankly did not make a great deal of progress this morning.
We're going to move into the lightning round, so I'm going to gather up a few, the gentleman with the beard, and then Bill, and then Dan. So.
Yeah, it sounds, I hope you're right about Congress going after this, but if you think it's been 4 years since the Abu Ghraib photos came out, it's been almost 4 years since the Biden memo was leaked. Torture is not an issue in this presidential race, and the use of torture confessions in Guantanamo is not very controversial. I mean, it doesn't seem to resonate with the American people that these processes down here are relying, the David Hicks case relied on torture confession. And it just, I wonder if American values have changed over the last 7 years. That's a question.
Okay. Bill Hartung.
Yeah, you mentioned that you thought this might be pursued more vigorously, Obama administration than the administration. I was wondering why you think that.
And then Dan.
As been noted, the mainstream media has not exactly been hot on the case of this story. If anybody in the White House press corps, other than, say, Helen Thomas, were interested in actually even posing questions about torture to, say, President Bush or Vice President Cheney, what questions would you encourage them to ask? And similarly, if David Addington actually does show up before the House committee, what questions do you think he should be asking?
Okay, go ahead.
Have American values. I just wonder whether you. I mean, do you want to have a first bash at that? Have American values changed?
Well, I've been teaching at William & Mary and George Washington now this is my 3rd year, and I have 20-somethings, as I call them, in my seminars, graduates and undergraduates. And I think the answer to that question is yes and no. Yes, in the sense that there are a lot of people in America who don't know what our values are anymore. And that's part of the failure of our public education system. When someone, for example, doesn't even know really what the United States Constitution says, or how it sets up our government, or how that's evolved over time, that's a real failure in what I call civics education, which I find all across the country as I travel now is something people look at you and say, what? We don't do anymore. The other aspect of it is that even if you can impart the kind of education that I think should be imparted to our young people throughout, not just when they arrive at William & Mary or GW, you have to give them a real-world flavor of what it means to adhere to those values and why those values are sacrosanct, why those values in some sense are more important than our security. That's a difficult thing to do, particularly when they've seen the scenes of 9/11 and other things that might be contemplated. We talk about a nuclear strike. That seemed to have fixated Mr. Cheney, for example. It so fixated him that I think he became somewhat paranoid in the aftermath of that thought. He even went to the Centers for Disease Control in Atlanta when he learned about the potential for smallpox. Came back and for 2 weeks was fixated on inoculating every American citizen. And so some very capable physicians and others advised him that not only was that not logical, it was perhaps dangerous. So these kinds of things can affect your thinking and get you off what is really, I think, an axiom, and that is our security is not worth our liberty.
There are many Americans who will sit and talk with me all across the country. California, Michigan, Texas, they've done it over the last 3 years as I've traveled, and tell me I'm wrong, and tell me that their security is far more important than their liberty. Well, they haven't had their liberty threatened lately. Not in the sense that, for example, Europe had its liberties threatened when Hitler was rolling. This is not Hitler, Al-Qaeda. The other aspect of it is, if you take the example of the American Republic, which after all sprang from your own country, if you take Magna Carta forward and the evolution of those ideas, the evolution of that process of governance, the evolution of those values, you bury bin Laden and Zawahiri and everybody else. You don't need bombs, bullets, and bayonets. All you need is your ideas. But you need to be an exemplar of those ideas. That's the way to defeat these kind of people. They aren't anywhere close to what the Soviet Union was. But insidiously, they could do a hell of a lot more damage to us by our reaction to them than the Soviet Union could do. And that's the kind of idea that you try to impart, or I try to impart to these students. And I think it needs to be imparted to a lot more than just my students. And the answer to the question, I think, is that yes, our values are extremely important, and we need a few refresher courses in them.
I'm obviously not in a position to express any sort of meaningful view on whether American values have changed, but I would look at the issues that give rise to the question in a slightly different way. America was attacked in a very brutal way 7 years ago, approaching 7 years ago, and I think it's entirely understandable for a country that has gone through that experience, and I happened to be in New York on September the 11th teaching at NYU, to take a direction, perhaps temporarily, which departs from some of its most sacred values. I mean, that in a sense is what happened in Britain in the early 1970s. Britain moved to aggressive interrogation and indefinite detention in the context of direct attacks on the mainland by the IRA. And it took a period of time for the country's system of government to adjust and reconnect to the basic principles that drove it. And I think actually that may be a better way of understanding what has happened. That the United States people have suddenly seen firsthand. They're not immune, frankly, from what goes on to other people around the rest of the world. I mean, you know, I've said this before, and I try to put it as delicately as I can, but many other countries are going through far worse things than what happened in the United States on September the 11th, and they struggle to deal with it. I mean, to give an example, a case that I was doing at the time that that was happening for the Democratic Republic of Congo in relation to the conflict, where you are talking of the deaths of millions of people in a 5-year period, makes what happened in Britain in the 70s, makes what the United States went through on that day in September the 11th, sort of pale in comparison, and doesn't automatically lead to the conclusion that the rules of the game have changed, as Tony Blair has said. And I just wonder whether it is, at the end of the day, nothing more than a shock to the system. The values of this country, I believe, are deeply entrenched. After giving testimony before Congress, I walked around the building a little bit. I mean, you only need to walk through that building and get a sense of the history, of the values, to know that at the end of the day it is going to take something rather more than a bunch of international terrorists to knock the United States off that course. And I feel at the end of the day I've just got to have more confidence in the people of this country and this country that this event of 6-7 years ago is going to transform the entire country. And as I think the law lords put it very pithily in one of the English cases that was analogous to Hamdan, Al-Qaeda, frankly, is not an existential threat in the way, I think, as you put it, that the Nazis were in the 1930s and 1940s. And what has happened is the administration has created an existential threat in order to create a climate of fear which allows it to drive forward a political and ideological agenda. I think that's what's happened. And people have fallen into a mess as a result of that.
And this program is facing an existential threat of time, so
Can I
what?
just deal
if
with
we
the two
could-
questions?
The Obama question and then also
I mean,
the questions for
the
White
Obama
House.
question is simply through a series of conversations with people in Congress over some period of time who have said repeatedly that they form the view that if Senator Clinton is elected, the message they're going to receive is, listen, guys, we've been here before. We know how to handle these things. Thanks for your efforts. Thanks for your advice. We'll deal with all of these issues. Whereas if Senator Obama is elected, there is, I suspect, a perception that he will be rather more open to doing things differently, including on this issue. In relation to the question from Dan, I don't think there is any utility in addressing to the President or the Vice President or to Mr. Addington big picture issues. This is a story about cover-up. It is a story about lying. It is a story about big, powerful people shitting on, sorry to use my language, smaller, less powerful people in order to protect their own asses. And that is the story. And the way to put questions is essentially in relation to a litany of lies that were made during 2002, in the late period, and 2003, and I would recommend in particular that you read the transcript of the press conference in the Eisenhower Executive Office on the 22nd of June 2004, and you can tick off the lies one by one by one, and then take Mr. Haynes's testimony before the Senate Judiciary Committee on, I think it was the 11th of July 2006, and tick off the obfuscations and the misleading comments and other things that amount, frankly, to a false narrative and a litany of untruths about what happened. And that is the way to focus on the issues and to get them for what they did, which is mislead Congress, mislead the American public, and present a narrative that is false. And I think that is the way to go.
Okay, we'll take two more questions. Here,
Thank you. I'm Diane Perlman. I'm a clinical and political psychologist, and some of my colleagues met with interrogators about sophisticated and non-abusive report building techniques. And of course, it's unreliable. That torture is unreliable as a technique, and there are much better ways of getting information than the ticking time bomb thing. But you know, I hear in public discourse people saying that they have gotten accurate information through torture. I think was it out here. So, do you know anything? Is that true? I mean, I've heard that also wasn't true. So.
okay, if we can get one more question, the final question, right here, please.
I would just like to ask either of you, I guess, to comment on whether you think these decisions or how these decisions would affect any attempt to prosecute any of the people that are in U.S. custody at the moment, whether in the military commission system that we now have at Guantanamo or at some later point down the road in U.S. courts. There are reports that teams were sent in to kind of clean up the evidence. So I wonder if you could comment maybe specifically on Muhammad Al-Qahtani, who's now facing the military commission.
Okay, the two questions, efficacy of torture, and then the
Let me shoot
impact
at
of
that one
evidence.
first, and then you can
Sure.
have all the rest. I was recently out at UC Berkeley and UCLA and Stanford Law School with a number of I'll put it this way, the guys who were recruited to or an attempt was made to recruit them, they're military people, judges, to the process. Two of them who had been recruited left after 2 weeks. One refused to be recruited. And I'm not a lawyer, but I listened to them talk about how this was impossible. Absolutely impossible. And it brought me back to the days when Wiltaf and Colin Powell said, ask, what is final disposition? Because if you are not prepared to keep these people, this was Guantanamo they were referring to keep these people for the rest of their lives, and that means half a century probably for one or two, because at that time we had 13 and 14-year-olds down there. If you are making a mistake, because you will never be able to bring these people back into any system of due process, whether military, civilian, or something you concoct, that the world will accept, indeed the American people will accept, and that you can get a conviction in and proceed, whether you put them in a maximum security prison in Colorado, whether you hang them, or whatever. That question still, I think, haunts this discussion. What do you do? And then when you combine that with the fact that I know that a goodly percentage of these people were simply swept up on the battlefield. They're not guilty of anything. You have a real problem on your hands, especially when you've kept them in prison for 5, 6, 7 years.
Well, it's obviously deeply problematic, and I've only focused on one of the individuals, Al-Qahtani, who of course is one of the 6 who's facing the death penalty. I have no brief for Al-Qahtani. I don't express a view on what he may or may not have done in the past, but plainly the treatment that he went through is going to make any material that was obtained in relation to that process completely inadmissible under any rudimentary system of justice, and frankly is going to taint the entire process entirely. That view was put by the counter group that was down at Guantanamo that was strongly opposed to these techniques being used. One of those was a clinical psychologist to whom I devote an entire chapter of the book, a guy called Mike Gellis, who was with the Naval Criminal Investigation Service, and who I spent a lot of time with, and from whom I learned a great deal, and who was deeply involved in that process. It's he and his colleague Dave Brandt who went off and essentially found Alberto Mora, who then intervened as the General Counsel of the Navy to bring this whole process to an end. I also spoke with, as I describe in the book, the man who was the head of Al-Qahtani's exploitation team. An exploitation team is the team that assesses the material that is being produced, so to speak. And I have to say that it's one of the points to tick off on the box. The administration stands up and says, this is what we got out of Al-Qahtani, point 1, point 2, point 3, point 4, point 5. Frankly, I've spoken to the people who were in on the interrogations. That's not what they told me. And I describe in the book what they got. And I think it was put as there was some historical and contextual material that was useful. That means nothing in my parlance. They got nothing. And I am deeply skeptical. I don't have any information on it. I haven't looked at it about the interrogations of Khalid Sheikh Mohammed and others about what they got, because the seasoned interrogators that I've spoken with, and it's a consistent message, is that when you engage interrogations of this kind many months or even years after the event, you're not going to get anything at all that is useful. Basically, people will tell you under those conditions whatever they think you want to hear in order to stop the pain. We heard this morning this very curious allegation. I'd not heard it before from the Senate, from the House Committee Minority Leader, that the 3 examples of waterboarding were limited to a period of 1 minute each. And that within that 1 minute process, all this wonderful information was produced. Now, I'm not an expert on interrogation, but I've got to say that the idea that somehow you would, as Vice President Cheney put it, dunk someone in the water for a minute and magically produce all of this extraordinary information, and with Khalid Sheikh Mohammed, we know that the list is so long as, frankly, to make it completely preposterous. I am, I'll put it no higher than that, deeply skeptical. And I take refuge in what I'm told by people who do this and have done it for many, many years, is that these types of techniques do not produce any useful information at all. And that is the view also in the United Kingdom. I just want to conclude with one thing. It has to be said.
It's also the view of the Israelis.
Yeah, it's also the view of the Israeli military. But there's one final thing that has to be said. Everyone wheels out, it happened again this morning in the committee, ticking time bomb scenario. And there was a wonderful moment. There was just a brilliant moment. And I invite the journalists in the room to look at that on the transcript. When the congressman, and I think it was Congressman Davis, I can't remember who it was who did it, of Alabama, who really is obviously a star in the making, basically said to David Rivkin, now, Mr. Rivkin, can you give us a single example of the ticking time bomb scenario since you are supporting its utilization? And the answer, which I leave you to read and which I cannot possibly paraphrase effectively, was catastrophic to his own case. And that needs to be given ample publicity, because it basically... It was catastrophic for his own case. He destroyed his own case by his total inability to provide any sort of meaningful answer to that
Nobody ever has been
particular
able
question.
or something.
No one
For
has.
example.
No one is able to point to a single example of the ticking time bomb scenario that has ever arisen in which aggressive interrogation was used and information was provided. In fact, no one can even point to a ticking time bomb scenario, period, where aggressive interrogation wasn't used. It appears that it's one of these great mythical creatures that is piggybacked on to open the door to the kind of horrors, frankly, that we have all been subjected to in terms of the story that the administration has run.
People have asked me, why do the Egyptians and Syrians and others do this? You examine why they do it to produce confessions. They don't care whether there's truth that flows out or not. They just want somebody to confess to something, and then they hang them or shoot them or put them in jail for an interminable period or whatever. They're not looking for the truth. They're looking for a confession.
Give me half a minute also just to share with you. I did an
Please.
interview
They're
yesterday.
still sitting here, so
I did
you
an
can still
interview
talk.
yesterday that was really fascinating for this reason, not for anything that I said, but for what I heard. My interviewer played a clip of an interview between John McCain and Dan Rather dating back to 1997, in which John McCain rather powerfully describes the circumstances in which he wrote out a full confession to war crimes violations, horrors, targeting children and women in North Vietnam, basically in a context in which he thought he could not be broken, but in which the suffering he went through was so great that he basically gave them whatever he thought they wanted to hear. It's an extraordinarily powerful interview, and I think it just destroys the argument for the use of aggressive interrogation from someone who obviously is now a leading politician and who, until I think the 2006 period, played a really, really crucial and positive role in addressing these issues. And I sincerely hope, whatever position he occupies in the future, he returns to that role that he played.
Let us hope so. Let us hope so. And with that, I want to thank Philippe and Colonel Wilkerson. Thank you for joining us today. Please come back for more. We're going to continue this talking about how do we fix American national security. Thank you so much.